Mr. Mkiza, do you want to greet everyone? Over to you, sir.
Chairperson, it seems Mr. Mkiza has got a challenge. I'll just try and get him back online.
Okay. On that note, then we will move on to the next member of the panel, who is a member of the energy regulator, Mr. Willibrod Majola. Mr. Majola, you may greet the attendees. Okay, let me check the next member of the panel, Ms. Nomfundo Maseti, who is a member of the energy regulator and a member of this panel. Ms. Maseti, do you want to greet the attendees? Okay, maybe we may be struggling a bit in terms of connectivity with the panel members. May I request that I be given 1 or 2 minutes to just check on the availability of the other members. If not, then I will proceed, but I'll wait for the secretary to assist me with an indication as to whether the other panel members have been connected or not. Ms. Jansen van Vuren, please, if you can assist me with that.
Chairperson, I'm just asking IT to assist. We will have them online in a minute. Chairperson, we have Mr. Mkiza online at the moment. I think we can commence and we'll join the members as we get hold of them.
Thank you, Ms. Jansen van Vuren. I think on that note, we will proceed and do alert me when the other members have joined us. I do know that they had prior commitments and they have apologized. But those that are able to join, please alert me when they've joined. As I have introduced the title for this particular public hearing, I will repeat it. It is a redetermination of the electricity tariff application for City Power Local Municipality for the financial year 2024-25. And it's held today, the 20th of May, 2026. My name is Nomalanga Stole. I'll be the chairperson of this hearing, and I would like to introduce the members that are in attendance. I think I'm told that we have Mr. Muzuvukile Mkiza. Mr. Mkiza, do you want to introduce yourself and greet the attendees? Over to you, sir.
Greetings to you, Chairperson, and everyone in attendance. Thank you.
Thank you very much, Ms. Jansen van Vuren.
Chairperson, Mr. Majola has joined us.
Okay, thank you for that. Mr. Majola is also a member of this particular panel for this hearing. Mr. Majola, do you want to introduce yourself to the attendees? In the interest of time, we will allow Mr. Majola to introduce himself at the later stage. But Mr. Majola, just briefly, he is the full-time regulator member responsible for the electricity regulation within NERSA, and he's the energy regulator member. He is a member of this particular panel this afternoon. On that note, members, thank you very much. And I think to start, it is important to indicate that this hearing was duly advertised in the Government Gazette, the Sowetan Business Day, NERSA website, and NERSA social media platform. The hearing is held in accordance with the Energy Regulator Act, in which affected parties are given an opportunity to submit their views and present relevant facts and evidence to the energy regulator. The hearing is governed by the NERSA rules on public hearings, which can be summarized as follows. 1, all parties will be required to make their presentation under oath. 2, presenters have been allocated 15 minutes each, and 10 minutes have been provided to the panel members to ask questions. And 3, only members of the panel may ask questions to the presenters. However, any member of the public may submit their questions via email, and the email address is publichearings@nersa.org.za, and the panel would decide on how to deal with those questions that have been sent through this particular email address. And 4, should the presenters wish to present information they consider confidential, they should indicate that, and the panel will make a ruling on whether to close the hearing or have the information submitted in writing. The recording of this hearing, which is recorded by microphones, will be the official record of this hearing. And in terms of House rules for this hearing, I would like to please request everyone to switch off their cell phone or put them into silence mode, and as well as when those that are not presenting, or even the presenters after presenting, may I kindly request that they mute their mics such that others who are allowed to speak can get the opportunity to do so. And lastly, I am going to ask that after we have taken an oath with those that are going to be presenting, I will ask the presenters, if possible, to really switch off their videos if they can, unless, or rather, let me rephrase that everyone must switch off their videos at all times unless requested to switch it on. This includes the presenters where they feel that they may have challenges with the bandwidth. They should indicate that to me, and I will allow them to switch it off. Otherwise, they can keep their videos on. So those are the only people that are allowed to have their videos on. In terms of this hearing today, we only received 2 requests to make presentation. And we will start with the first presenter, which is from the City Power Local Municipality. And the presenter is Mr. Frank Hinder. Mr. Hinder, you may switch on your camera so that we can administer the oath. And thank you, Mr. Hinder. I take it that from City Power, you are the only presenter. You are not having a co-presenter?
Good morning, Chairperson. And I have a co-presenter, Chairperson. I would ask if we can also be sworn in. It's Lonabo Magid.
Lonabo Magid. Okay. All right. Thank you. On that note, Mr. Hinder, I would start with you. Do you have any objection in taking the oath?
I do not, Chairperson.
Okay. On that note, may you please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are going to give to this panel is the truth and the whole truth?
I do.
And for the record, may you please state your name, organization, and designation.
My name is Frank Hinder. I'm from City Power and the Senior Manager responsible for tariffs and tariff structures.
Okay, thank you. May we then have your co-presenter, Mr. Lonabo Mgidi, to also come to the camera so that we can administer the oath with him.
Good afternoon, Chair. My name is Lonabo Magida from City Power. My role is currently...
Before you do that, Mr. Magida, do you have any objection in taking the oath? Let's start there first.
I do not have an objection, Chair.
Okay, on that note, may you please raise your right hand and affirm the following. Do you solemnly declare that the evidence you are going to give this panel is the truth and the whole truth?
I do.
Okay, on that note, may you please state your name, organization, and designation.
Thank you. My name is Lonabo Magida, and my role at City Power is General Manager, Energy Trading. Thank you.
Thank you. Thank you very much. On that note, Mr. Hinda, I take it you're going to be starting with your presentation. Otherwise, you can guide me. If you are the one that is going to start with the City Power presentation, please note that you've got 15 minutes to go through your presentation, and the members will be given 10 minutes to ask questions or issues of clarity based on your presentation. Over to you, sir.
Thank you, Chairperson. I will do most of the presentation and it will be on the following topics. We will just briefly look at the history of this cost of supply studies and imperative that applications should be based on cost of supply studies. We'll be looking at the responsiveness of our updated COS to the court submissions that were made by the applicant, the limitations on the Nersa'S framework for full compliance with EPP. We'll look at the MYPT methodology and its context as far as the policy position 1 is concerned. We'll reflect on the key findings of this cost of supply study that suggests that the increase should be about 27.07%, though it is only indicative, and we will clarify why we are suggesting is that that finding can at best only be indicative. We'll look at the complexities of cross subsidies in the absence of an enabling policy framework. We'll look at when our proposed increase per customer category, and then in terms of the way forward, or rather the predicament with respect to the way forward, we will speak into that and then take discussion questions and answers, Chair.
Okay, maybe Mr. Hinda, sorry to interject. If it's still possible, may you kindly email us this particular presentation because we do not have it, and it will make it easy for the proceedings of the hearing to go smoothly, if you don't mind. Over. Thank you. But you may proceed, sir.
Indeed, Chair, I was supposed to say that I did send it about 1:15 to the officials. So it is with Nersa'S officials.
Okay, all right. Thank you. You may proceed, sir.
Okay. In terms of the basis of the cost of supply study, as you know, that we are from the background where municipal tariffs were approved from the basis of the benchmarking. And City Power was one of the first entities to start complying with the COS framework. At the time when we first submitted our cost of supply study, the Nersa'S framework was still not in place, so we did it essentially based on the NRS 058 directives. We then updated the cost of supply study based on the Nersa'S framework. And then obviously we know that there is a court case and a court finding, an Ake Forum judgment that compelled that everybody should base their studies based on the cost of supply, base their submissions and tariff application approvals on the basis of a cost of supply study. Now, subsequent to that, there was a City Power, what I would refer to the City Power judgment, which is not necessarily about compliance issues, but in terms of the substance of the cost of supply study. Now, in terms of that judgment, there is concerns about interest cost that is to be excluded from operating because it should be included in terms of rate of return or as part of the return on assets. We are going to move away from surpluses in favor of a return on assets. There is issues around how depreciation was calculated, and as the customer also felt that we should do away with all forms of cross subsidies. We have submitted the application that as our best attempt to comply with the being responsive to those submissions that were made. First, our cost of supply study was updated. It excludes the interest charge to the value of about 264 million, rather, that was excluded from the operating cost. We moved away from surplus in favor of rate of return. Therefore, the application is no longer based on surplus, but it's updated and based on cost of supplies, suggestion of a return on asset. The proposed return is, however, indicative due to limitations in terms of full compliance with provisions of the EPP, as we will outline as we go forward. With respect to the depreciation calculation, we then used our replacement values for insurance purposes as for the replacement value of our assets. We used the remaining useful lives as used for historic costs based on our accounting policies. We then benchmarked our WACC. We didn't calculate the WACC. We then benchmarked it only against the Eskom distribution application WACC, and therefore what we have submitted is approximately around what Eskom distribution has submitted, because given that we are in a similar business, so the risk profiles are fairly similar, but it is only indicative. Again, in the same way, the proposed return also has got its own limitations due mainly in terms of the provisions of the EPP, for which there is a predicament in terms of our ability to comply. With respect to the cross-subsidization, Chairperson, it is quite clear that there is it is dependent on the cost of supply study, and also there is an envisaged EPP policy position 4 envisages as a policy framework which needs to be in place to assist that process. And now, in terms of the limitations, just reflecting on them, Chair, I'm not intending to go through all of this, but just to illustrate the point that there is still in the framework as it stands, there is still a significant reference to margins. Surplus, we're talking about the surplus that has to range between 10 and 20%. There is a process. So indeed, a lot of reference to surpluses, but at the same time, in the context of the cost of, the City Power judgment, the judgment is quite clear that we should move away from surplus in favor of rate of return. The same can be said about provision of interest charges. If we look at the policy, the framework, the table 1, which is on page 7 of 29, it includes interest on loans as part of the cost plus methodology to be included in the cost. There is further paragraphs that define what interest will be covered and what loans must be considered in terms of the interest cost that must be included as part of the operating cost. But the judgment again suggests otherwise. The WACC also refers to interest calculation, which is then consistent with the cost of with the judgment, where it says that we should base it on a WACC which should then be applied on a return on asset. Therefore, and if you have both in the methodology, it may then amount to double dipping. In terms of the regulatory asset base, the framework refers to the fact, and I would want to emphasize the 7.2, which speaks to the fact that the framework simply says that we must use index historic cost to determine the replacement value. Now, that may be in contradiction to the EPP, because the historic cost would lack the ability to be an instrument of accurately reflecting on the replacement value of the asset. There are further provisions in the framework that speaks to how it should be done, in emphasizing the base that the historic cost should be the basis of the asset valuation and therefore depreciation. Again, that is not consistent with the EPP policy with respect to replacement value determination being the basis of valuation. So indeed, this limitation puts its Achilles heel on our ability to comply, and we are therefore clear that we have submitted the application to the best of our ability, but it has got its limitations, especially if we look at the provisions of the EPP, which speaks to appropriate asset valuation that must be adopted by the regulator after public consultation, and it must accurately reflect the replacement values. Now, the Nersa'S framework refers to historic cost, which is accounting values, which then cannot be the basis of replacement values, especially when it comes to appropriateness and accuracy thereof. For example, if you look at the ESCOM MYPD methodology, there is attempt or it is seen to be perceived to be in full compliance with the requirements of the EPP policy position 1, and we will touch on that. We therefore are saying that the cost of supply framework as it stands in its current format cannot be a basis for a lawful redetermination as far as this application is concerned. Not going to reflect too much on the ESCOM one, except to say that it is very clear. If you look at the MYPD methodology, paragraph 9.1, it says that the EPP policy position 1 is the basis of the asset valuation as far as the regulatory asset base is concerned. And as a result of that, further provisions in the policy, in the methodology, clearly demonstrates how in that case there is an attempt, or maybe a successful attempt, if we want to call it that way, in terms of complying with the provisions of the EPP. And that is lacking as far as the policy cost of supply framework is concerned as it stands. Nevertheless, we have done an update on the cost of supply study. In terms of it, a few points that we would want to highlight before we go to itself. First, that the bulk purchases cost is limited to meeting the projected demand only. And then there is a separate allowance for energy losses, however limited to 15%. In our case, slightly higher than what the Nersa framework suggests. Therefore, it then results in a disallowance of energy losses to the value of about 3.06 billion, which simply is disallowed, and it then means that City Power over time has to strive to reduce its losses to be within the benchmark by and therefore unlocking that disallowed revenues. As far as the operating costs are concerned, we excluded depreciation and the finance cost as directed by the courts. We then took, as directed by the framework, we then took the operating cost of the AFS of 22-23 and extrapolated for CPI, excluding depreciation and finance cost. Otherwise, we are aware of the levels of our bad debt provision, and we are putting measures in place to be able to, in future, improve on that, and as well as we're looking forward to future benchmarking, of course, essentially from an operational efficiency point of view. As far as depreciation and return on asset is concerned, we then have used our replacement values for insurance purposes and the benchmark work as indication of our aspiration for future compliance with provisions of the EPP. We have done a calculation which then we say it is only indicative. Again, this study itself, we agree that it cannot necessarily be the basis for a lawful redetermination because it is not based on a Nersa approved methodology. The replacement value is ours. The work is not necessarily calculated because we thought at this point in time it might be fruitless and wasteful to spend resources in trying to calculate the accurate work while the asset valuation basis is not fully established. This is the indicator that it then says that, again, we are looking at a revenue requirement of 24.8 billion, suggesting an increase of 27%. However, depreciation and return on asset, it's only indicative numbers as we have for reasons as we have outlined earlier. Again, confirming that the 3.06 billion excluded for energy losses in excess of the benchmark, which we have put at 15%, which then means that the allowed cost is reduced from what would have been about 27.9 to about 24.8 billion, but only indicative. In terms of the cross-subsidization framework, Chairperson, there is a policy position 4, which has got a number of provisions that on face value may appear to be contradictory, but maybe they are not necessarily. The first sentence of the EPP 4 says that price discrimination must be identified and removed. However, it also says that either when those are permitted under a specific cross-subsidization development framework, or don't remove it, let it be transparent and transparently reflected to fully unlock the potential of electricity to all. It then seems to suggest that there is a need for a cross-subsidization framework to guide for appropriateness of the level of cross-subsidization. If it's left to industry, we may not agree between the customer and the utility in terms of what is appropriate. But more importantly, the policy framework seems to suggest that EPP policy position seems to suggest that there must be a framework in place. But it also says that cross-subsidization should be allowed provided it's transparent. It seems to suggest that there should be consideration for access to electricity. There must be avoidance of energy poverty. Importantly, cost allocation drivers and methodologies to be scrutinized so that they are balanced and equitable. And also there are other provisions in the EPP, for example, policy position 34, 36 and 44 that also need to be taken in consideration when dealing with issues around cross-subsidization. Now, when we talk about balancing the the basis of determination, the cost drivers, we have City Power's cost of supply study is based on the Nersa'S model, but it is refined with respect to certain aspects of the cost drivers where we found it to be more differently adequate. It then suggests that if it is to be implemented, that as it stands, assuming that the study is correct, and if cross subsidies are to be completely removed, it then suggests that certain customer categories will have to be subject to price increases that may well be unbearable. For example, the prepaid customer residential, maybe we have to move from currently about 2.70 cents to about 4 cents. So some of these cost drivers, Nersa needs to not just accept it on face value, but also assess it for equity, provided there is time for certain reassessment, as we are suggesting towards the end. Otherwise, we'll not go too much into, in terms of this application, Chair, we have noted what the cost of supply seems to suggest, but because it's indicative, we're asking for the increases to remain as they were originally submitted, therefore looking for an overall increase of 12.72. In terms of the way forward, Chair, and again, we are first ones to admit that it is a predicament, because the Nersa updated cost of, Nersa would need to update its cost of supply framework to be in compliance with policy and legislation. Nersa updated asset valuation methodology must have, and that includes issues around dealing with the asset valuation methodology. Once the asset valuation methodology is updated to comply with provisions of the EPP, Nersa will be required to subject that to a public consultation and then include it in the framework. And then City Power will have to be allowed some time to do the revaluation. And only after that, we may have to do further update on the application based on the update, and if we are to ensure that we are approving tariffs that are based on fully compliant policies and policy frameworks. But we also are very clear that even if the framework is updated, and even if the updated study, further updates to the study suggest that the tariff should be increased, we envisage that we will still want to keep the 24-25 tariffs at the levels at which they are, and maybe look at future tariffs in terms of further compliance, because we appreciate that the cost of supply study findings it is a journey, and it will have to be achieved over time. And given our energy losses and where we are, we can also not achieve fully cost reflective tariffs in isolation of reducing energy losses. But we are also very clear that based on the indicative findings, that any cost of supply study that is fully cost reflective is likely to be higher. And we want to stress, Chairperson, that when it comes to the cross-subsidization framework and implementation of cross-subsidies, it cannot be done in isolation of a framework. And secondly, it cannot be done in isolation of implementation of cost-reflective tariffs, because if you remove a subsidy from the industrial customers, you have to inevitably transfer it to the customer that is contributing to that cost. So redetermination that will be based on the current cost of supply framework in its current format will therefore be untenable, not only for city power, but indeed for the electricity sector, particularly the municipal sector as a whole. I submit, Chair.
Thank you, Mr. Hinder. I don't know if Mr. Magida wants to add anything before I give the panel members an opportunity to ask questions. Does he have any addition to make?
No, the intention is for him to assist with the responses to
the responses. Okay, yes. All right. Noted. Thank you very much. On that note, thank you for your presentation. And I would like to now request the members to ask questions or issues of clarity based on the presentation that has been made. Members, any input from your side, please? If you have any, raise your hand. I will recognize you. Thank you. Thank you very much and welcome, Ms. Maseti. I will start with you. You may come in, ma'am.
Person, can you hear me?
Yes, I was just going to say you're muted. We can hear you now.
Okay.
You may proceed.
All right. Thank you, Chairperson, and thank you to Mr. Hinder for the presentation. There's a couple of things that I just want to get clarity on. The one that I would like to start off with is around depreciation and the returns. I just want to find out first as to how did you manage to calculate appropriate depreciation without providing or at least demonstrating evidence to Nersa that this is your asset stack and your asset register, and this is the value of the assets that are utilized to assist City Power to operate the distribution facility. Where are these assets that you are using, and what is the value of those assets? You correctly cited position 1, and you will see that in position 1, there are 2 things that are emphasized. One is the calculation of the returns, or a profit commensurate with the risk. And then it goes on in the last part of position 1 to make reference that those should be based on an appropriate asset value. That is in the EPP, so that one does not choose at what point you comply with the EPP and at what point you don't comply with the EPP, just like you have heavily cited the EPP. So for me, that is the starting point. How did you calculate depreciation? How did you calculate from the depreciation to get to the return, so that you address the concerns that were before the court, that you then use the return as opposed to the surplus? And we would like, therefore, to be clarified on that aspect, so that in our reasoning as NERSA and in consideration of the redetermination, we make sure that those things have been dealt with and have been corrected. The second thing that is linked to that position one vis-a-vis the return as well as the profit margin, you will note that step one of the COS framework, which deals with the determination of the revenue required, inclusive of the profit margin. How did you deal with that aspect there? The emphasis is on the profit margin, which is part of that first step of the allocation of cost. The framework has to do with the allocation of cost. That would have been part of that revenue that is required, of which revenue must allow the profit margin. So clearly, there are one that must have been done. So if you can clarify us, how did you arrive then at those costs, and for you to be able to calculate the return or the margin? And then the second thing that I just want to find out is around the issue of the cross subsidization. You are saying that you are making, citing the different options that we are provided, like the broader discretion that is given in the policy. Now, for purposes of an increase that is requested, which increase must be spread across customers. If it's 12%, the 12% is applicable across the customer categories. Clearly, that is an average, and therefore it will impact on the customer categories differently. So, have you done your own assessment to show, when you now have this revenue versus, or the tariff versus the revenue, and then try to split that across the customer categories, so that you can see how that impacts on those customers, so that there is a transparency in respect of how much, as well as the implications thereof. And remember that allocation is also accommodated in the COS framework. I think it is step 4 of the framework, and then the rate design. So it is there. So I just want to check on that. And then there is this issue that you kind of say that for City Power to fully comply or to comply, it means certain things must be done by NERSA. I just want to understand, what is it that makes City Power, that constrains City Power in ensuring full compliance if there is the section 15 of the Electricity Regulation Act read with the EPP. The COS should comply with those provisions. And in fact, for compliance, full compliance, nothing stops City Power from reading these in harmony, ensuring that empowering provisions of the law are complied with fully, and you read that with the EPP. And it does not mean that if there is any inconsistency arising from a framework, that the framework takes precedence over the empowering provisions of the law. My question, and I probably repeating it, having stated this, is to find out what constrains city power in ensuring that it will consider these in harmony to make sure that city power does comply. The last question that I have is the one around inefficiencies pertaining to energy losses, for instance. And I'm referring, to energy losses, which are the non-economic losses. What are you suggesting that Nersa'S should do in this assessment? Because there are risks to the erosion of the revenue of city power because of the risk that you are faced with, of which risk are supposed to be within the control of city power for you to protect your assets, for you to make sure that the collection rate is improved, for you to make sure that you put appropriate and sufficient measures to protect your revenue. All of that is expected from city power. So how would you expect NERSA to approve a tariff that entails inefficient cost, of which cost ought to have been dealt with and addressed through measures that city power should have put in place? Those are the things that I would like to find out, and therefore whether you are going to do some downward adjustment on the revenue that is required so that you take care of the risk of wanting a revenue that is higher, yet you are not correcting the inefficiencies pertaining to energy losses. And therefore, that would suggest that the entire risk is pushed to customers and there is no risk sharing principle that is applied. That is all from my side at this point, Chairperson. Thank you.
Thank you very much, Ms. Musetti. Mr. Mkhize, you may come in.
Thank you very much, Chairperson, and thanks, Mr. Hinda and Makita. From my side, well, got about 4 questions. One is City Power talks to a national cross-subsidy framework. Are you suggesting that this be a top-down instead of maybe a bottom-up, where municipalities look at their own, cross-subsidy frameworks? And in that regard, also like to know if you have any of any semblance of a cross-subsidy framework, particularly for city power. And then I note also that you chose the rate of return, whilst there are also challenges around the asset valuation issues. Why not opt for cost plus methodology? Was there anything that precluded you to pursue that route? And a link to that would be in terms of the issues that were contested in court. In terms of the judgment, do you think you've sufficiently covered those? And then on the issue of revenue collection and energy losses, I would like that you reflect on that and maybe even to touch on how you are progressing in terms of improvement on that front, particularly from the public interest, as well as what measures have you put in place to address these. That will be all from my side. Thank you.
Thank you, members. And I think from my side, what I wanted to get clarity on is with regard to the public participation process. Just to check if that process has been done by City Power, and if it has been done, has it been completed? Because as a regulator, we would want to get that input. And again, noting the fact that it was one of the issues raised in the court papers. So if City Power can appraise us on that particular point, it will be appreciated. And one last point linked to a point raised by Mr. Mkiza on energy losses is just to get clarity as to why did City Power use 15% when in actual fact the framework that we have developed is quite clear to say that the cap is at 12%. So those are just 2 points of clarity from my side. I do not see any other hand from the members. And on that note, Mr. Hinder, I'll hand over to you to respond to the members' questions. Thank you very much.
Okay, thank you very much, Chairperson. Maybe it would be appropriate to start with the question around why did we not use the cost plus methodology. And that should take us to the slide where we talk about responsive. Our application is attempting to be responsive to the court submissions. Now, there is a judgment that says the manner in which the City Power cost of supply study was done, and therefore the resultant tariffs are not lawful. And a number of issues have been raised with respect to that. The first one being the issue around the use of interest cost. We say we shall not include interest cost in terms of that one. The second one is to say that you shall move away from surplus in favor of rate of return. Our study was based, we had a surplus as guided by the cost of supply framework. The judgment essentially suggests that that is unlawful. So our application initially was submitted based on the framework as it stands, and that was found partly to be non-compliant. So we don't have an option of using the cost of supply framework. And that only, it gets the impression that it affects City Power only, but it's only because there is a City Power judgment that looked at the substance of the cost of supply studies that was done specifically for City Power. It looked at its substantive compliance. The Agri-Forum judgment is more about processes and having a study to start with. So it is not yet at the level where the customer asks us to say, no, but your study is not compliant with the Electricity Regulation Act and specifically the Electricity Pricing Framework Policy, and specifically Electricity Pricing Policy Position 1 and Position 4. And so you shall start to address that, and that essentially is the case. In terms of whether you have done a public consultation and so on, Chairperson, this cost of supply study was, or the application, the redetermination application was done at the back of a judgment that had a very tight and a specific timeline. And I would, given what the judgment said, that there shall be public consultation, but it will be done under the auspices of Nersa. So we simply did not have the time, and notwithstanding the fact that the judgment didn't call for it specifically, we didn't simply have the time to go back, or the luxury of time to go back to our customers and reconsult with respect to the redetermination. However, we have made an effort to make the customers aware of the process. Even when we are having a consultation with our customers, we then indicated to them about what was going to happen today, and encourage them through our media and public relations side of our business to try and make sure that they encourage customers, make customers aware of this. How did we come to the in terms of how did we calculate the replacement, the asset valuation, and so on? What we are saying is that we have used our insurance values. Now, for insurance purposes, we have a detailed asset register, which we have shared with Nersa officials, which is the insurance values as at 22-23 financial year. We have then extrapolated that for the 2 years, which is the 23-24 and 24-25 financial year, and then we have gotten that value. We have also shared our certificate of valuation from the insurer to say that City Power assets are insured, but in fact, because that valuation is based on today's prices, which is 2026 prices, it's in fact at values that are much higher than what we have used, but that is insurance valuation that it comes from. In terms of the work, we have then, as we said, we have simply benchmarked and not gone out to physically calculate that, but we have a work with about 6.3%, which is approximately comparable to what Eskom distribution has, and we have also submitted the detailed calculations as part of the cost of supply model. But we are, why are we, maybe just to clarify in terms of the asset valuation using this slide, to say that City Power is saying that, notwithstanding the fact that we have made calculations based on valuations that we have done, we are the first ones to admit that it is not in full compliance with EPP policy position 1, because it says it must be a Nersa adopted methodology. It must be used. Not just any valuation methodology, it must be Nersa approved. And when it's Nersa approved, it cannot be anyhow as suggested in the current policy framework. It must be reflective of the replacement values. Now, reading and also speaking to the question of about the margin, reading it in conjunction with what the Act says about a profit margin. That, the Act says that it allows for a profit margin that is reflective of the risk, undertaken of the business or the activities that we are undertaking. However, when you read that you are to read that in conjunction with the EPP policy position 1, because it then attempts, or policy position 1 goes further and then describes in terms of how that replacement value should be determined. And it says Nersa shall have adopted a methodology and for City Power to use that. The EPP, the cost of supply framework otherwise is clear on how to calculate the work, which we have taken note of and which we intend to comply with. However, for purposes of now, because we don't have an appropriate asset base, we didn't put resources in place because it would have taken some resources to go and calculate, look at, determine a City Power specific beta and looking at specific risk appetite in the market, and based on that come up with appropriate work as calculated, as informed by the framework. So we haven't done that as yet, but we are fully committed to doing that when it is appropriate. We are then not able to apply for the study even suggests that it should be a 25% increase, looking for a revenue requirement of 24.8 billion. We are not applying for that because how we determine depreciation and how we determine the rate of return, it is a makeshift improvisation, which we admit is not in strict compliance with the methodology. But we must all acknowledge that it is indicative of where the revenue requirement is likely to be. But as it stands now, it is not defined. That 24.8 can only be indicative until we are able to calculate that number correctly and this number correctly. In terms of the energy losses, Chair, why haven't we limited it to 15, not to the 12%? Again, we fully agree that if you reduce it to 12%, then it's another 400 or 600 million that will be taken out of that number of 2.5059 billion. It will then increase this number accordingly. And then that revenue requirement would then be slightly lower, say 26 point some odd percent. But we have the exact number of what it is likely to be if you are to reduce it accordingly. But in any case, we are not applying for the 24.8% 24.8 revenue requirement as the study may suggest, because we are hamstring. We are not allowed at this point in time to use our cost of supply study. But the court has said we cannot use the cost of, the COS framework. Hence, we are in a predicament, not just as City Power, but as collectively as parties that have to make a resolved around this. Hence, we are saying that the only lawful decision would be to suspend, to go back to court and ask them to delay, and the court processes will allow, the judgment allows for that delay, and for us to do the right thing of developing the methodology so that City Power is able to submit a cost of supply study that is compliant. And it's not just City Power, because the court has simply said, as it stands, the framework, not in its entirety, but a lot of the aspects of the framework, as I have indicated, are not usable and should be discarded going forward. If not, it then puts us, everybody, in a predicament. Maybe if I can ask Lonabo maybe to add around the energy loss activities that we have, activities that the city is undertaking to reduce the energy losses, including maybe reflecting on the fact that we have installed check meters. I hope we have covered all the questions that, Chair. Over to Lonabo, Chair. Thank you. With your permission, Chair.
Thank you. Mindful of the time, we do have the presence. If Ms. Magida can be brief, but there's one question that I think you did not answer. It is on the public participation process. But let me allow Mr. Magida to come in, and I also would like to give an opportunity to the members of the public hearing to also come into just if they have any follow-ups. Mr. Magida, you may come in.
Thank you, Chair. I think I missed your comments on the initial part because there was some echo, but I could clearly hear on the last part of your comments. So in terms of the question on public participation, I think Frank did respond to that by saying if one looks at the judgment in terms of the 24-25 tariffs and what obviously was prescribed as part of the redetermination, we did not pursue our own public participation. the only public participation that is or was expected to happen from a City Power point of view is the one within the context of the judgment, not separate. So specifically for the 24-25 redetermination, City Power has not undergone through a separate public participation process. So if I then move on, Chair, on slide, I think it might be slide 21 or so, where we start to see the impact of cross-subsidization. I thought that slide first showed what the prices would be in relation to compliance to the methodology that we followed. But then once you establish, at least once we have established the true cost to serve, we then throw in the element of cross-subsidization. And hence, I think even as articulated to say what you eventually see is the average increase. So I think there was a slide, I think it was 21, where you see what happened from the true cost that we could have applied for to the one that actually gave us the 12.72 instead of the 27, because then the 27 would have been a number driven by true cost without cross-subsidization in between the categories. Now, talking about cross-subsidization, Chair, I'd like to talk to another question in terms of the National Cross-Subsidy Framework, which is one of the questions that came up. At least in our view, while we do have a view in terms of how cross-subsidization should happen within our customer base, it would help a long way in terms of making sure that our processes or our limits or we are seen to be doing this within certain parameters. And that's what we are asking NERSA for, because at least that's our understanding in terms of the complainant in the case that we saw, where the customer was saying they're tired of or they cannot carry the burden of cross subsidies. Unfortunately, at least in our understanding, the cross subsidization is a key component of the EPP. But the only, at least one of the key things that's there is that it must be transparent without necessarily having come out with clear parameters. So that's what we are asking for from NERSA. So then
Mr. Magida, sorry to interject. Please be time conscious. We have other presenters. I've allowed you, City Power team, really generous time. So we do need to proceed with the others. So if you can just be brief in your remaining responses.
Thank you, Chair. I'll talk to the losses and the revenue collection. We had started, Chair, with the deployment of check meters from our side, from a City Power point of view. We started at ESCOM level and we are going all the way down into the networks. And the exercise is obviously to make sure that we have a meaningful system in terms of our energy accounting. Coupled with that process, Chair, there is a drive that National Treasury is pursuing in terms of trading reforms. There is a plan in place there. I'm sure we can share that with NERSA in detail in terms of how do we want to move our losses from the current levels, obviously, to within the benchmarks. So that plan is in place. Thank you, Chair.
Thank you, Team City Power. That is Mr. Hinda and Mr. Magida. Please don't go away. I'm just going to allow the panel members to ask any follow-up questions that they may have based on your responses. Members, any follow-ups that you may have? Thank you. I see a hand from Ms. Masiti. Ms. Masiti, may come in.
Thank you. Thank you, Chairperson. Chairperson, I just want to find out from City Power. what City Power expects NERSA to do with an application that is not compliant, an application that is not going to address issues that the court said must be addressed. And in addition, you have also repeatedly made admissions that the application and the components of the applications are not in compliant with what you are supposed to do. Starting off with the very first question that I asked, how did you go about calculating depreciation when the issue of the asset values has not been dealt with, so that we know what we are working on? And you improvised. You're coming up with insurance valuation as to what it would cost in the event of these assets. Something happens in these assets, they get lost or whatever it is, then insurance comes in. Insurance will then put some replacement cost on your assets. So that's not what the EPP say you must do. And it is not necessarily what our regulatory framework says you must do, even in terms of the modern equivalent value or the cost or the replacement cost. So these two things are not the same, and in fact in our regulatory framework they are not there. So that's the first thing, and it's a fundamental issue that you need to address, because now we'll end up with these matters, and for NERSA to bring this before NERSA, it will take us back to court, all of us, because you're bringing something that is not in the regulatory framework. So that's the first thing. So there is no compliance in regards to that. Secondly, I would like to find out, just to assist us in this process, what are your sort of, or did you consider your audited figures for 2024, 2025? And in those audited figures, did you then separate out the distribution assets, the assets that you utilize for the provision or for the operation of the distribution facility for electricity service? Did you separate those out? And based on that, what is the appropriate depreciation associated to that? And that's what I'm not getting. Then, in addition, for purposes of the risk and the work that you said you needed, or you have some challenges in doing it the way that you are doing. So this is the third part. Again, on that work, for you to be able to now come to the reasonable return. Again, on that, you are again indicating a challenge. And remember, that return is one that is specified in Section 15 of the Electricity Regulation Act, read with position 1 of the electricity pricing policy. So that's very clear. There's nothing that is not clear there with regards to what is required in terms of the return. It is there in the legislation. So and I have already indicated that the fact that COS is there, it does not mean that you must not comply with the legislation, because those two documents, they take precedence over the COS framework. So those are the things, Chairperson, that I thought we've got to put these questions before the licensee that has already been in court, the licensee that must come to the regulator and demonstrate to the regulator that it has done everything and made an effort to then comply with the law. But we can't then accept other new things that are introduced, other methodology and options that you will say you submitted to the team, that in terms of the insurance, these are the assets that are insured in the event that there is a loss. I'm putting the words because that's how insurance work will come in. If there is a loss event, the insurance is likely to then replace these assets at this much value, or to reinstate or replace. So in as much as there's still replacement cost aspect, it is not the same. Let me leave it at that, Chairperson. I'm not going to dwell on the others about the surplus. We all know the issues of the surplus, but also the one that now he answered is on the issue of how much could be taken out when one does the downward adjustment to make sure that there's risk sharing insofar as the energy losses are concerned, so that NERSA does not look at a revenue and tariffs that entail inefficient cost. And the last thing is that it is going to be a challenge then to base any tariffs on the COS, your cost of supply study. That is not proper at all. Yes, I mean, you should have time to do it right, and then we base it on an appropriate cost of supply study. I'd like to leave it at that, Chairperson, in terms of our own scrutiny of what is before us, what City Power is trying to propose to NERSA. Thank you.
Thank you, Ms. Maseki. Any other member? I don't see any hand. I think for me, I would like to come back to this issue that I've raised on the public consultation, and just to get confirmation from City Power if it is their view that the public consultation was not necessary, since this application is a redetermination. And if I'm correct in terms of what I've heard in the responses, I just want to find out from them, how do they then expect the public to get to be informed of some of the changes that they have made in this resubmission of their application to NERSA? Because I noted in one of their slides, they are referring to the fact that NERSA will undertake the public consultation. I think it's important to really indicate that there are two public participation processes that needs to be done in any application, which is the licensee must conduct their own public participation process, and NERSA must also conduct their public participation process. So I just wanted to highlight that the NERSA process of public participation, it's a NERSA process required in terms of our processes, and I believe that the City Power or licensee has got its own processes. One of them is to consult with the public that are going to be affected or that may have an interest in terms of what they are applying for, whether it's a new application or redetermination. So I just want them to confirm that that is their view, that it was not necessary, but to cover it with the NERSA public participation process. For me, I think it's not right, as there are two processes that needs to be done in terms of consultation. Thank you. You may come in. I'm going to just give you 5 minutes to come in with your responses. If you believe you want to submit written responses, you may be given that particular opportunity, but you need to formally request it from the panel members, because we do have other presenters that we need to really consider. And I believe we are running out of time. Mr. Hinda or Mr. Makida, let me give Mr. Hinda an opportunity to wrap up in 1 minute, please, sir. I don't know, maybe he may be muted. If he is, please unmute yourself, and as I've guided, you either respond or indicate that you'll respond to NERSA make a request to respond in writing. Mr. Hinda?
I was muted, Chair, and I have just fixed that. Yes, I was saying it is an important question that has been asked in terms of the completeness of the application. But it is also important to be noted that it was not possible for the application to be complete. So the implication, therefore, what we are suggesting is in the bullet point number 1, is that we will have to together and not as go back to the drawing board in terms of NERSA reviewing the cost of supply framework to be in compliance with the EPP. Now, legislative provision speaks loosely about, in the Act, there is reference to the profit margin, which is fine. The challenge is the EPP, and it must be read in conjunction with the EPP. The EPP prescribes a specific methodology that needs to be followed. That methodology is not there, so it is not possible to follow that EPP methodology. So any other decision, or any attempt to make a decision on the basis of the cost of supply framework as it is, and we've referenced it, we can, and for example, we have asset values with the regulatory asset base, as City Power is a ring-fence entity. The asset values are split between regulatory and operating assets. But in any case, and the regulatory asset base is supposed to be, which is the historic cost of asset values that we have, which is from the AFS, and is strictly supported by values that can and were in fact provided because the AFS has been submitted. But it will fall short of the court provision that we must comply with the EPP. But that is really the bottom line in terms of the challenge that we are sitting with. And it holds the same for the public consultation, Chair, that we're not saying it is not necessary. It is necessary, but we are busy over implementation of a court directive, which has specifically outlined timelines and matters that needed to be dealt with. Hence, it was submitted in that context. But more importantly, we still sit with the dilemma that whatever numbers that we will present to the public is only indicative, because the cost of supply framework needs to be reviewed. City Power needs to be allowed time to go and do its valuation on the basis of that reviewed methodology. And in that case, we will then submit the asset valuation that is compliant with the electricity pricing policy position, and only then would that then be possible for a redetermination. It also means when going back to the court to say that between now and June, if that's what we do, to go back to the court to ask for more time. And the court will understand and it will be a reasonable request, because this time is required. Otherwise, whatever decision which we make will not be lawful, and we will then back and forth between our officers and the court. Just briefly on the policy framework, our impression is that the EPP seems to suggest that there is a national need for a national policy framework, because for two reasons, Jeff. It seems to suggest, but secondly, you don't want industry, we are regulated, and you don't want us to self-regulate, because otherwise there will be 285 different approaches to cross-subsidization, which may not serve the purpose for which framework may be. I submit, Chair.
Okay, Mr. Hinder, I think I've given you enough time. Members, I think we can wrap it at this stage in terms of the presentation from City Power. However, if they believe they still want to augment their presentation, they do have 7 days within which to do that, if they believe they do need that. And members, on that note, are you comfortable with the fact that we must move on to the next presenter? And thank you very much, Team City Power, Mr. Hinder and Mr. Magida. We'll then move on to the next presenter, and the next presenter is from RSA Cluster Group and NPC / Autocast, and the presenter I'm called Mr. Stephen Jardine and Mr. David Mertens. If they can just indicate to us if they are going to be doing a joint presentation. If that is the case, I'll have to conduct an oath on both of them. I see Mr. Jardine's camera is on. Mr. Jardine, are you going to be co-presenting with Mr. Mertens?
Madam Chair, yes. We both have different aspects that we want to talk to. Maybe with the discussion that's taken place so far, it seems that everybody's in agreement is that this is not going to happen in a hurry. And Joburg's not ready for a tariff discussion. So I think let's assume both of us will speak, but I don't want to just go through the same information again and again, but we'll see how we're going as we go along. So perhaps read us both in so we can both make comments should we feel that are relevant to today's discussion.
Okay, thank you very much. On that note, before you can start, I'll just have to swear or really make it take indicate if you have any objection in taking the oath. Do you?
No, I don't.
On that note, then, may you kindly raise your right hand and affirm the following: that do you solemnly declare that the evidence you are going to give to this panel is the truth and the whole truth?
I do.
Okay, for the record, may you please state your name, organization, and designation?
My name is Stephen Michael Jardine. I'm the Managing Director of RSA Clusters, which is an industry activity. I'm very interested in these type of things because this is where we sort out what needs to be done.
Okay. On that note as well, may we take Mr. David Mertens, or rather carry out an oath with Mr. David Mertens?
Yes, I'm here. Thank you.
Switch your camera, Mr. Mertens. Oh, yes, there you are. I can see you. And do you have any objection in taking the oath?
I don't have any objections.
Okay. On that note, may you kindly raise your right hand and affirm the following. And do you solemnly declare that the evidence you're going to give to this panel is the truth and the whole truth?
I do.
Thank you very much. For the record, may you please state your name, organization, and designation?
I'm David Mertens, and I'm consulting on behalf of RSA Clusters today.
Okay, thank you, gentlemen. You do have 15 minutes. I don't know how you're going to split it amongst yourself. And I'll also give the members an opportunity to ask you questions. And I take it that Mr. Jardine, you're going to start first, and you let us know when Mr. Mertens needs to come in. Thank you. Over to you, sir.
Thank you, Madam Chair. I do have a presentation. I'll put it up for sake of just to give some pictures and ideas of where we actually are. But at the same time, I think it's fair to say is that we probably need to talk to this important subject in a very mature way of looking at things. And I think, I don't know if you can see the slide that I've just put up. It's just about us, just to see that you can see us.
They are not yet up. Try again.
Okay, just take one.
Don't know if members can see it. From my side, I cannot. Members, can you see it?
No, I've gone back to the. Try again. Okay, you should be able to see it round about now.
Yes, I can see it, and I take it that the members can see it as well. If they don't, they will alert me. You may proceed, sir, with your presentation.
Okay, so I think this is very important. We've been listening keenly to what's happening, and I think in every aspect, very often we think like islands. And I want to actually just speak to that, is that industry is not an enemy. Industry is actually out there. We've got a common issue that we've got to deal with, and that is to get to the kind of resources and utilities that we need. So in this space here, it's a partnership, and we want to actually understand where your costs are. We want to understand where you're moving to, and we want to understand that you're going to win, because if you don't, we don't have electricity and we don't have a business. Now, I think that part of the problem that we're sitting with at the moment is that we don't have a proper identity about exactly what we want to do. And I'm going to put it to you, Madam Chair, and also to the City of Joburg through Mr. Hinder, I think certainly from our perspective is we don't feel that there's an industrial agenda that's really running. We're just those guys who are in the corner who make a lot of noise and make a lot of smoke. That's not true. We're a major contingent in the city. And as we start talking about the strategies and the implementations in and around the city, and we're just thinking about industry as being a nuisance and just they use lots of electricity, we're seeing things wrong. And I don't think that the city's actually got their strategy right from an economic development perspective at all. I've used this word here, Josie's identity crisis. What is Josie? Josie is this fast-moving services, nice place to be sort of type thing. And it is. Joburg's a beautiful place to be. I was born there and bred there. However, we need to think about this as a business. This is a business that we're talking about of electricity. It's not unlike any other business in any other municipality or even in industry. We've all got certain things that we can do and certain things that we can't do. But first and foremost, we have a responsibility to our business to make sure that we do our business properly and that we actually look after the business and that we get to a point where we have an identity for our business that is clearly for everybody, not necessarily just for certain groupings and so forth. So I suggest as part of the extension of what's been suggested today is that City Power needs to understand who they actually are. They're not just part of Joburg. They're a very important business to many, many industries across the whole of Johannesburg. Secondly, I think is that weak decisions in the past have really given us a very, very difficult environment for all of us to work in. So if I take a perspective where there's an expectation on us, not only from the municipality, but from national government, from industry, and from the whole society, we want Joburg to win. But we got to remember is that in this imperative, there's a deal here. The deal is that we need low-cost electricity. At the moment, the cost of electricity is just out of the window. And that's something that you need to consider because you're not going to get the money from industry. Otherwise, they're going to leave. And in actual fact, I'll tell you is that a bigger part of the problem is that many of them have left already. So where we sit with here is, just to give you an example, 91 industrial spaces in Johannesburg. Every single manufacturer in those 91 industrial spaces is looking for stable and affordable electricity. These guys, they number probably hundreds, I wouldn't say thousands, but probably hundreds of industrial businesses. They're starting to include data centers. They're starting to include more logistics. They're starting to include less manufacturing. Now, I get the impression from talking to Johannesburg that they really want to actually have a good footprint of manufacturing. But money talks, activity talks, performance talks. Joburg's not doing a good job and companies are leaving. What does that do? Well, they're going to other municipalities. And those other municipalities are the ones who are going to be providing. What you're going to be sitting with as City Power is going to be a whole lot of services, little companies, SMEs, unable to actually pay the kind of costs that are needed in order to support the industry or to support the city of Johannesburg in all its needs. And that strategic discussion needs to take place pretty quickly, because if we just go a little bit further, for us to actually start talking about the potential to grow, I think it's very easy for us to talk about, but I don't think it's a discussion that is going to be quite friendly, because industries like everybody else need to have a good, sound business that they do business with. And in the way that in the way that the tariffs are structured today, we found ourselves in a particular situation where the cost of electricity to business is far higher. It's totally out of kilter with what it should be against international norms, but far higher. And the city of Johannesburg is the most expensive metro from an industrial point of view in South Africa. Now, that is terrible. We have about a 50% variance to what the Eskom direct tariff is. What we need is we actually need to have industrial on a tariff that is similar across the whole country. If we didn't have the divergence of the municipalities taking their piece of the pie, what would happen is that we'd actually have a fairly even kilter. We've got to the point now where we are actually upsetting the status quo and the order, because some municipalities are just so expensive, Johannesburg, and others aren't. And maybe Cape Town and so forth are good targets there. But what we are seeing, what makes us worried even more, is that the business risk that is attributed to city power is huge. And part of what we're seeing is that we're not doing the basics right. The financials are late, so we're not seeing the accounts available for 24-25. But we're not seeing that it's a organization that's really getting ahead of the game and starting to fix these problems. What we're rather seeing is that financial losses, poor performance, dysfunctionality. And you sit here with these figures here, you can see them yourselves, but the money's rising. Every year we want more money because we're getting further behind. Guys, that's a one-way ticket to nowhere. So that has to be fixed. And then we certainly didn't leave Eskom out of this, because I think Eskom does have some context and some responsibilities in making sure that electricity remains affordable. And certainly the way that Eskom has been behaving in recent times is actually pushing up the cost of electricity to everybody, being distributed by the municipalities. And what we have is a huge tax base, which actually is looking to get decent tariffs from you. And we can't do that if we're not going to look at this seriously. We cannot have a discussion around a topic which is technical. It's not about ifs and buts and whys and whens and how and whatnot. It's technical. It needs very specific things to be done. It needs very, very specific ways to do your finances. It needs very specific ways to do your cost of supply studies and your applications and so forth. The whole of Joburg is hanging on for this moment to actually say, yeah, we're going to have a decent tariff now. And I don't see that coming at you very fast. What we see is we're compromising. And because we're compromising our customers. In this case, I talk about industry. They're compromising industry. There's energy losses, which were way ahead of the maximum that's allowed. It's been talked about, so I won't go into that too much detail. But I think more importantly is we're unable to determine a lawful tariff for our customers. And how does everyone deal with that? Do we get to the point where Joburg is unmanageable? We can't afford that. And the material errors and inconsistencies that get made, this is not how you do a big business. And City Power, to all extents and purposes, is a massive business. And we need expertise in there that is going to actually help us to get to the levels where we are looking to get to. We want to be number one city in Africa. Absolutely, all of us want us to be there, but we need to actually work together in order to get there. City Power cannot recover from the inefficiencies and from the challenges that they are being tackled with, of their own making mostly, I will add. But the problem being is at some point in time, when you get to the point of having no money, you can't generate. And it's just a law of diminishing return. And I think we've got to be careful about that, because that's really something that we're worried about. However, I do think that if we start focusing around what we can do to actually make the Joburg economy effective, we have to think about every day what the agenda is in terms of growing that industrial economy or other sport economy or whatever it might be. But I do put to you is that we need to think about industry first. not domestic. And that's an error that a lot of the municipalities are actually making, is that they're going for the domestic first, don't have enough to actually do industry, start loading industry. We are fighting for global work. I'm going to repeat that. We're fighting for jobs in this country. If we don't have enough manufacturing doing what they need to do, we're going to have Chinese people doing the jobs that you are doing currently. So I want you to think about that very carefully. We need low cost, and we need to see that Joburg starts looking at proportioning their costs accordingly to actually get us there. I know we can bring in solar, we can do all kinds of other stuff that's part of the plan, but we need a strategy from Joburg in terms of what they're going to do. And it needs cooperation, and then we do need to fix the mistakes. There's lots of mistakes made. We make mistakes, that's true. So we're not calling anyone out. It's just a matter of we need to have that cohesive strategy. And then there's a whole lot of other challenges that obviously, as we start getting to the technical detail, also add into it. So I think, Dave, if you'd like to make a couple of comments.
Thank you, Steve. Thank you, Chair. Steve, can you move on to the next slide, please? So I think the reason why we are here is obviously that City Power's tariffs were declared unlawful in January. I will not really repeat the basis as to why they were declared unlawful. I think we discussed it already quite at length during City Power's presentation. But really, what we looked at is whether there was an improvement in the reapplication from City Powers versus the original one. So Steve, if you can scroll on. So then City Powers reapplication, it's a failure. And I think we have already seen that it's a failure during the previous presentation. And the application cannot form the basis of a lawful tariff decision. We will discuss the revenue requirement portion of it, and then also the tariffs per customer category and some other items. The first item I want to show, Steve, please go back one up, is the bulk purchase cost and the losses. The cost of supply framework provides us with a clear view as to how the losses what losses can be allowed, but also how it needs to be calculated. And I just, on top here, I made a, let's say, extract from the cost of supply methodology. So basically, you take your sales kilowatt hours, if that is 100, then you add the allowable loss factor, whatever it is. The cost of supply table 1 shows 10%, but we know 6.1 in the cost of supply framework allows up to 12%, but the 12% must be calculated based on the sales. So if there are 100 kilowatt hours of sales, the total required or allowed purchase can be 112. And there's no other way to calculate it other than this methodology, which is ingrained in the cost of, in Nersa'S cost of supply framework. And what we see in this application and in all the applications of the other municipalities, this table 1, the calculation methodology is being violated. So if you look at the extract of the cost of supply what City of Joburg has done, they say that they applied for 15%, but it's actually not accurate. If you use this methodology, the 2.45 billion rand of losses actually amounts to 18.2%. So this whole application was based on a so-called allowed loss percentage of 18.2%, which is obviously completely, in violation of the cost of supply framework. So if you apply the 12%, you get a completely different number, and the delta is actually 836 million. 806.836 billion rand. So that is where we are with this application. And then furthermore, City of Joburg is not only buying from Eskom, they also self-generating through Kelvin Power Station, and the average cost per kilowatt hour is 1.88 cents. per kilowatt cents per kilowatt hour, or 188 cents per kilowatt hour. If you apply that, there's another reduction of revenue requirement by almost 100 million. So the 836 million plus 100 million makes a difference to the revenue requirement of 930 million rand, by which the revenue requirement, this application is overestimated. So that's the first point I wanted to take. So Steve, please move on to the next one. Then there's another point we want to make around operational cost. So it's clear for us there's operational costs which are extracted from the audited financials. And one good thing about City Power is that they are audited financials on an annual basis, although 24-25 has not been published as City of Joburg is late, but at least there are audited financials. But we cannot really verify whether operational costs have been incurred efficiently. And apart from the efficiency, let's say, corrections which we do on the bulk purchases and the percentage of losses, it's for us, it's still open what the methodology will allow. But what we do know is that City of Joburg incurs costs. The costs are based on losses which are as high as 30%, while the allowed losses are only 12%. So if you look at all your operational costs, the paying customer will pay too much if they pay for all the operational costs, because there's also let's say the excess losses which are included, or the cost for the excess losses which are included in obviously the operational cost. So if you correct the 6.4 billion which is allowed in operational cost, or which City of Joburg applied for in the 6.4 billion which was applied for, and you correct it and you spread it over a 12% loss, then you actually, again, you reduce your allowed operational cost by 900 million rand, which is absolutely substantial. So if we can go to the next slide, then I think the assets and the issue regarding the assets have been debated at length with Mr. Hinda. I think it's in a way good that the whole discussion was brought up, and the issues which we have with this. We just wanted to make an additional remark that the way City Power evaluated the assets, and also the net depreciated value, which then determines the RAP, it actually comes out to a claim where City Power says its network assets are only 8.7 years old. So you look at the value of the assets. This is now network assets only, is revalued at 46.9 billion rand, and the net depreciated value was valued at 35.118. So only 10 billion out of the 46 billion rand has been claimed as being depreciated. City Power uses an annual depreciation rate of 2.6%. So basically, the life of the assets on average are 38.5 years. So then, if you work it out, the 10 billion stands for a depreciation of level of 8.7 years. So I do think that everybody will agree with me that it's an unlikely claim of City Power to say that their assets on average are only 8.7 years old. So we believe this whole asset valuation is indeed way too high, and the numbers that appear then in the revenue requirement are highly exaggerated, and we definitely would recommend for Nersa to reevaluate the RAP. See the next point, please, for slide. Thank you. So then, we only see a part of it, but we also discussed the tariffs per customer category in the previous discussion. They do not reflect the costs, the outcome of the cost of supply per customer category. So generally, that's a violation of EPP policy position 2 and also position 26. So the 2024 original tariff application simply ignored the outcome of the cost of supply study. And in our view, the reapplication is even worse from that perspective, as it kind of just remains silent on the matter. There's nothing in the application letter, and actually in the cost of supply, if you look through all the tabs are in the cost of supply, a lot of the tabs that actually refer to the tariff per customer category were actually deleted from the cost of supply study. And cross subsidies are linked to this effect. I think we also really discussed it. Cross subsidies have not been determined, nor have they been considered, so that this makes this whole application obviously completely unlawful. I just would like to make one remark regarding cross subsidizations. ESCOM actually did a lot of work in their 2025 restructuring. Tariff restructuring, they covered cross-subsidization at length, and I think City Power should actually have a look at what ESCOM has done for the 2025 tariff redetermination. So we then, Steve, come to the next slide. This table has come up. Mr. Hinda also presented this table. It really says that with this, although they apply for an average increase of 27%, which we obviously believe that the total revenue requirement of 24.8 billion has been greatly exaggerated. But let's take into account that it would be right, then industries should basically get 2 to 3% increase. Nevertheless, industry has been given a 12.7 increase. So this really, this table from the cost of supply illustrates the vast difference between the outcome of the cost of supply and the tariff application. And it really shows that business and industry remain overcharged by City Power if the application would be as it stands. So this is really unacceptable, and it really leads in big discrepancies between the City Power customers and other customers next door, where the tariff determination has been done much more in line with the regulation, and they are obviously referred to the ESCOM tariffs. There's another last remark regarding the content, which I would like to make. There's not only problems on the lower revenue side. I also think the income and the revenue which have been calculated for City of Joburg seems to miss out on street lights and the cost to supply municipal services. I cannot see a trace of revenue from street lights and municipal buildings in the cost of supply study. It just does not appear. So there would be a violation of EPP policy number 40, and then other customers would be subsidizing these services, and it's not transparent. And obviously, the calculated 27% increase will be further reduced if streetlights and municipal revenue would be included as a revenue, as the required increased percentage would be calculated as less. So I think that's another pertinent consideration, and it's also a problem in many other municipalities. Then our conclusion and way forward. So obviously this is an historic tariff determination, but I think the whole situation comes to the conclusion that the application cannot form the basis for the lawful tariff determination. Ms. Massetti, I would like to thank you because you have obviously acknowledged that fact in your comments based on cross-subsidization and asset valuation. Then we are very concerned about City Power's electricity distribution being financially unsustainable and being a major burden to the productive economy, including industry. It's a burden potentially to ESCOM, to general socio-economic development, and actually to Johannesburg as a city itself. So we recommend that Nersa reject City Power's tariff application as the base for lawful tariff for 24-25. So thank you.
Thank you, Dad.
Thank you very much, gentlemen. I take it that your presentation has come to the end, and I would like to allow the members of the panel to come in with questions or issues of clarity. Mr. Jardine, is that the end of the presentation?
That is the end of the presentation, and yes, we'll happily take questions.
Thank you. Members, any questions or issues of clarity that you may have on the joint presentation by Mr. Jardine and Martins representing the organizations? Members, questions? Ms. Masetti, I see your hand is up. You may come in, ma'am.
Thank you very much to Mr. Jardine and Mr. Mertens for the presentations. Just one clarity for me on the account. I don't know the slide number, but the one that shows the 2%, 2 point something percent increase to business. Just to understand, what does that entail? What costs are included? Are you suggesting that the increase that must be levied on business, it should just be 2%? That's the first question. And then the question linked to that also is, what does it entail? As you know, that I think step 3 of the cost of supply framework, it allows for other charges such as capacity charges and all of those other charges that must be included before the allocation, cost allocation. That's the first part. And then the second part, does it entail a certain percentage of cross subsidization? I just want to find out about that. Thank you.
David?
Thank you, Ms. Masetti. You may come in, gentlemen. I don't know who's going to start. Mr. Jardine, let's start with you, and then we'll take.
I will take that response. Thank you. Thanks, Ms. Masetti, for the question. So the 2% is an outcome of the cost of supply study, and you can find it on the cost allocation summary, the Excel sheet of the cost of supply. So basically, it says that the current tariff, average tariff for year 1 is 2.76, and the projected tariff as an outcome of the cost of supply is 2.8. Looking through the cost of supply, that is the total cost, including capacity charges, everything. So it basically says the industrial LPU, time of use, MV, should get a 2% increase for the outcome of the cost of supply. And that is also before cross subsidization. But note that this is based on a total revenue requirement of 24.8 billion rand, which we then have shown also, and I think during the discussion with City Power, which we acknowledge that the number of 24.8 billion revenue requirement is very likely also an exaggerated number. So if you then reduce the revenue requirement, then that 2% will become even less. So that is really the outcome of the cost of supply study, which was presented by City Power. And that is before cross subsidization.
Okay, thank you, Ms. Masetti. You covered, and I think on that same slide from my side, I see the street lights and robots. We're saying there is no cost for that. Are we certain of this, that this particular service does not bring a cost to the licensee? If I can be clarified on that. Thank you.
As I say, this slide is an outcome of the cost of supply study from City of Joburg. And that is also why I made a remark saying that street lights and robots and also municipal services in general and buildings do not generate any revenue. So it looks like City Power doesn't get paid by City of Joburg for the street lights and actually the consumption of municipal services. But I think that's a question which you really need to ask City Power rather than us. We can only see what is presented to us, and with what is presented, we doubt that it's actually creating revenue for City Power.
Okay, thank you, Mr. Mertens. I thought it was an extract of
Yes, thank you.
a recent table that was provided on the revenue requirements. Mr. Steve?
This table comes from the cost of supply study, the Excel sheet, cost allocation summary tab. That's where it is. You will see it if you open that tab.
Thank you, Mr. Mertens. Ms. Masetti, are you covered?
Yes, Chairperson, I'm covered with the clarification. That's why I wanted to just check what is entailed in that 2%. And I've got the answer. Just to find out in terms of where this process is, because the way things are and the admissions that were made, it is clear that there's still another step. But I just want to find out from you, gentlemen, as to whether you believe what is suggested by the licensee here is something that, in terms of its ability to come up with a proper, compliant cost of supply, because it seems that's where it should start. So City Power seems to suggest that there's a need for NERSA to amend its cost of supplies framework. Well, put that aside, but the question I would like to find out is that the real constraint. If others have done it, is there a constraint on the part of City Power to come up with a cost of supply study that seeks to comply with the Electricity Regulation Act, with the provisions of the EPP, and also the cost of supply framework, and read those in harmony, but ensuring that the empowering provisions of the law are complied with? Do you believe that really, according to the kind of sequence they seem to be suggesting, that, oh, well, NERSA, you must first do this, you must first amend, and therefore maybe that will be the time that will be able to comply in terms of coming up with the cost of supply study? Do you believe that is the right way of doing this?
Ms. Masetti,
thank you.
Sorry, it's Steve Jardine. It's a good question, but I think, to be fair, is that this is a regulatory issue, and for us to actually comment from a public perspective, we should really say no, because this has been something that's been in the coming for a long time. There's been a lot of pressure on the regulator and a lot of pressure on the municipalities to actually start implementing what's in the EPP. So the longer it draws out, the longer people are suffering. Now, I think the problem that we're sitting with here is we forget to understand the pressure that we are putting on our residents and consumers. It is unfair, and while we make a strong case for the economy in Johannesburg, is the fact that the economy is suffering, individuals are suffering, businesses are suffering, and we need to know exactly who pays what to whom when. Now, I understand that Joburg is in a real pickle at the moment, and I think the problem, as I illustrated to you, was the business isn't right. And because the business isn't right, what's happening is that we're not counting the rands and cents. We're trying to make sense of a big pool of money that we've got, but people are playing with it. And that needs to stop, because there's no room for any of that activity to take place at all. So if our colleague, Mr. Hinder, suggested that there needs to be specific processes, well, they should be specific and clearly outlined to every municipality. It shouldn't be that there's one municipality or more that are finding that this is difficult. But I do think that the fact is that there are municipalities that have actually submitted their tariffs without making those concerns, really tells us something as well. But the truth comes into whether or not those other applications are actually going to pass the muster either. And that's really a big question for us at this stage, is that in this conversation, we've got to get away from where you're muzzling industry and you're giving them the opportunity to go ahead and grow the economy. If they don't grow the economy, they're not going to grow jobs. What do we need right now? We need jobs. And we need people to be able to live comfortably and to get the return for what they think they're doing, to be able to live and enjoy being in Johannesburg. So I think the challenge is much bigger. It's just a matter of we need to stop actually blaming others, and we need to actually look at what our responsibilities are and get a move on with it. And I'm not trying to single out any individuals in that. I just think we're not really focusing on what we've got to do. It's the same thing in terms of the, if we want to actually have an agenda for industry, we need to have an agenda for industry, and there needs to be a proper strategy in place. And I don't feel City Power has the strategies in place around economic development and about the power that's needed to actually support it as what they should. That's my submission.
Thank you very much, Mr. Jardine. Mr. Mertens, anything from your side so that I can confirm with
thank you for also asking me. I think the elephant in the room is obviously the fact that City Power as a distributor of power is bankrupt. So we are looking at a bankrupt business now, and we're having discussions about RAB and efficiencies to some extent, but a lot of technical issues, but City Power is bankrupt and no longer capable of recovery, because this has now come over at least 10 years where there's been a gradual decline in the performance of City Power. And then about 2021, it came to a point where there's absolutely, where the financial losses came. These financial losses have grown year after year. So the last year reporting, they were more than 3 billion rand. So how does a distributor like this turn around and keep things going for the citizens and for the industry? And that is a point where Nersa, as a regulator, has to step in and decide what they're going to do with these kind of distributors. Just let it happen and make a tariff determination once a year, but the underlying non-sustainability is actually completely crippling. And we all know Eskom's 110 billion rand, which they have on their balance sheet for municipalities which haven't been able to pay Eskom. So this situation cannot continue. And if it continues, it's going to be to the detriment of everybody. And there must be a solution, a long-term solution, which I think we believe Nersa is a very important part of to kind of stop these kind of financial losses and distributors which are bankrupt and have no way out.
Thank you very much, gentlemen, for your input. Ms. Masetti, are you covered with the response to your question?
Yes, Chairperson, I'm covered. Thank you very much.
Okay, thank you very much, gentlemen. And I think we do not have any other member who wants to raise a hand or give input. And on that note, I would like to then thank the panel members and our presenters for the presentations that they've made to us at the Nersa management and staff, and all those who have been following us in this particular hearing. And I would like to indicate that we've come to the end, and I would be adjourning the hearing. Thank you very much, everyone, and have a blessed afternoon.